All right, hello and welcome to this concept class on the basic structure. This is the second class on basic structure doctrine, and here we are going to take a look at the cases and judgments that led to the evolution of basic structure. In the previous concept class, we have discussed that what were the implications of the basic structure, what does it mean, what does it mean with respect to the powers of the parliament, what does it mean with respect to powers of the judiciary, and how the role that it has played, the basic structure doctrine has played in the maintaining the system of checks and balances, as well as how it has to some extent saved Indian polity from taking a completely socialist direction. It has also had several criticisms which we have discussed in the previous class. Now here we'll take the cases and the judgments. So all of you have the handout for this case, the basic structure cases and judgment handout. So if you see the doctrine's evolution, primarily we have to know that it was a contest between several ideas. The basic structure doctrine's evolution was not just a not just a judgment, but it was a clash between several ideas and ideology. At first, it was a clash between between Article 13(2) and Article 368. All right, Article 13(2) says that any law, any act of the any law or regulation that violates the fundamental rights under Part 3 can be declared null and void on the grounds that it does so. And Article 368 lays down the powers and procedure of amendment of the Constitution and vests it with the Parliament of the country. Right? So, if you see this, India has a pretty strong parliament limited only by the Constitution compared to United Kingdom. If you see, so limited only by the constitution compared to United Kingdom, if you see, which does not have a written constitution, there also the parliament is powerful, all right, but and also not limited by the constitution, given that the parliament and the judicial pronouncements, as and when they come, they make up the constitution. But in India, the parliament is limited by the constitution. So if we see the basic structure doctrine, it was a contest between also individual the ideas of liberty and the idea of equality. From the idea of liberty, from the idea of liberty is born the doctrine of rights, that individuals have liberty and therefore individuals have rights. From the idea of equality is born that the state can take policy decisions, can pass laws for equitable distribution of wealth. From the idea of liberty, we get the doctrine of rights. We get it gives foundation also to the economic system of capitalism. Right, liberty ideal, it gives rise to the political system of capitalism, which means that freedom must be given to all, to the markets. From the idea of equality is born the socio economic system of socialism. So if you see, this was a contest between the community rights that is the right of the community for land acquisition, as well as individual right to the property, individual right to property, which was a fundamental right under Article 31. It was also a contest between the supremacy of parliament versus supremacy of the judiciary, and fundamental rights versus directive principles of state policy. Right? Some of the important articles or provisions that you need to know with respect to these judgments and this evolution of the basic structural doctrines. First is Article 13(2), which says that any law that violates rights in Part 3 shall remain null and void. The second article that you need to know is Article 368, which lays down the powers and procedure of the Parliament to amend the Constitution. The third is Article 39B and Article 39C. Article 39B and C are Part 4 of the Constitution, Directive Principles of State Policy. Article 39B states that the state must operate in a manner such that it is able to reduce inequality, or it should reduce inequality. There should be equitable distribution of wealth. And Article 39C talks about the state operating in a manner such that it prevents the concentration of wealth in the hands of few. Then you need to know Schedule 9. Originally, the Constitution had 8 schedules. 9 schedule was added by the first Constitutional Amendment Act, which said that any laws, rules, or regulation placed in the 9th schedule, any laws, rules, or regulation placed in the 9th schedule will not come under judicial review. So now, as all these cases, the legal evolution of the basic structure doctrine happened as a response to the state governments, the states and the union, the governments primarily, zeal to implement land reforms. Zeal to implement land reforms. This would not be possible without acquisition of land from those who had more of it and giving it away to those who had less of it. So these were in the pursuit of uh, pursuing the socialist policy of the state. This was also because after independence we had made promises that zamindari would be abolished and tenancy rights, which means that the tiller of the land who was working under the zamindar, he will get land rights. So there was zamindari system had been abolished, but zamindars were still there. Land was supposed to be taken by them. How could that be taken? Given that there was a big impediment in this, that impediment was through the Article 31, right to property as a fundamental right, which was guaranteed by the Constitution. So this is a problem. However, the states undertook land reforms and gave land rights and tenancy rights. The land regulation acts were brought up by various states. The land regulation acts, which said that, which put a ceiling on how much land the landowning class could have, individuals could have. So all these things, in response to this, the zamindars individually as well as as a group, they lobbied both in the parliament, but more so in they've contested cases in the high courts and supreme courts, different high courts and supreme courts, challenging the the challenging that is the state's right to take away their land when it was right to property was a fundamental right under Article 31. And second, the state's ability to take away the fundamental right. And C, the state's ability to or the parliament's ability to amend the constitution. Right, the parliament's ability to amend the constitution. So if you take the first case, the Shankari Prasad versus Union of case, now this was a Mr. Shankari Prasad was a zamindar of Bihar. Right to property was, he said, then when his land was taken away by the government, Bihar government, he said that right to property is being infringed upon, and therefore, while he took the case to Patna High Court, right, what happened is the government brought the first Constitutional Amendment Act, which did not take away Article 31, that is right to property, all right, but added Article 31A and 39, 31B and 9 schedule. All right, the ninth schedule uh, provided for a ways and means by which the Union Parliament could place state reform, land acquisition laws in a way such that it would be outside the judicial review. All right, so this was also challenged in Shankari Prasad case, and the issue became that can Parliament amend the Constitution? The Parliament had amended the Constitution to add Article 31A and 31B as well as added uh, and said that any act or law placed under 9 schedule would be outside the jurisdiction of judicial review. All right. So this was in clear violation of Article 13, which said that any law that takes away fundamental rights under Part 3 shall be void. However, in the Shankari Prasad case, the judiciary did not want to take a very strong action against the parliament, and anyway we had just gotten our freedom. All right, so the judiciary's stand was that amendment that the parliament has done and creation of ninth schedule. All right, this amendment that the parliament has done is not an ordinary law. All right. The Constitution had guaranteed the right to property as well as other fundamental rights, and to ensure that these fundamental rights were not taken away by the Parliament, had placed Article 13.2. Right, 13.2 said that any law that seeks to take away the fundamental rights will be null and void. However, when limitations on this Article 13 were brought, and with the addition of Article 31A and 31B and the creation of ninth schedule, the Supreme Court held that these amendments, which were brought by the Parliament, they were in the nature of amendment to the Constitution, and they were not an ordinary law. So, if it is not an ordinary law, if an ordinary law tried to take away the fundamental right, it could be very well null and void. But an amendment to the Constitution was not an ordinary law, and therefore the laws were not null and void, and therefore the parliament would have the power to take away the fundamental right, but only through a constitutional amendment. All right, and it therefore established the supremacy of the parliament over the judiciary. It established the supremacy of Article 368 over Article 13. The parliament had a superior position over the judiciary. Then came the second case, Sajjan Singh versus the state of Rajasthan. So this was a completely different case But the question of amendment to the constitution again came up in this case, that led to the doctrine of basic structure. In this case, Sajjan Singh was a sub-inspector in Rajasthan police. The case was completely different. The case was that he was appointed by an IG, but he was dismissed by a DIG. So therefore, he contested that under Article 311 of the Constitution, he cannot be removed from his position by an officer who is lesser in rank than the appointing authority. However, when the case went ahead, the context of the case changed, and uh, the question came whether the question again appeared with respect to the amending powers of the Constitution. All right. So here, it had upheld the verdict of the Shankari Prasad case. It said that the amendment to the Constitution is not an ordinary law. That the amendment to the Constitution, the Parliament performs two functions. One is a legislative law by which it creates law. The second function is a constituent function by which it works like a constituent assembly and creates or amends the Constitution. Amendment to the Constitution is not a legislative function but a constituent function, and therefore it is not an ordinary law and therefore does not enjoy the protection that is guaranteed under Article 13(2) against any such amendment. All right. Then next case which followed was, so by this time there was an atmosphere that the judiciary has failed to protect the individual rights of the citizens. And something like happened in the Golaknath case was the state of Punjab, where different, the courts took a different turn. In the third case that we'll see today, Golaknath versus state of Punjab, again a similar situation had happened with respect to land reforms. Here, what had happened is William Golaknath and his family had a lot of land. So Punjab Land Regulation Act came. Am I audible to you? Am I audible? Sorry, there was a brief interruption because of some issues. So William Golaknath versus state of Punjab. Here again, Punjab government would try to take away the land of William Golaknath and his family. All right, and the 17th Amendment was brought. The 17th Amendment had placed these Punjab Land Regulation and Land Sealing Acts in the 9th schedule outside the scope of judicial review. All right. So this all the first Constitutional Amendment Act, the fourth Constitutional Amendment Act, and 17th Constitutional Amendment Act, all these amendment acts have tried to place certain state laws in 9th schedule. All right. So the first outcome of this case was that the Parliament, it said that the Parliament had no power to abridge or take away fundamental rights. In the Golaknath case, remember the major outcome was that the court said that there was the constitutional amendment was like any other law. There was no difference between a constitutional amendment act and any other act of parliament, and therefore it was an ordinary law. Because it was an ordinary law, therefore it was subject to being declared null and void under Article 13(2) if it takes away the fundamental right. This was the first thing. From this thing came out that the parliament had no power to abridge, reduce, or take away the fundamental rights. All right, and therefore, because the parliament had no power to take away the fundamental rights, Article 368 was given a lesser status than Article 13. And from this case, the outcome was the judiciary said that Article 368 does not confer upon the parliament the power to amend the constitution. Article 368, the Golaknath case, William Golaknath case, Article 368 does not provide the Parliament the power to amend the Constitution. It merely lays down the procedure for such an amendment. It merely lays down the procedure for such an amendment. The government was a bit alarmed with this, and the government came up with the 24th Constitutional Amendment Act, which said that limitations of an act being declared null and void under Article 13 and 2 would be applicable to all laws except Constitutional Amendment Acts. The 24th Constitutional Amendment Act was brought, which said that while Article 13 and 2 was correct, that any law that violates fundamental rights can be declared null and void, any law that deals with any law that deals with fundamental rights can be declared null and void. Any constitutional amendment act would not be a law that is covered under Article 13(2). So therefore, it tried to restore the superior position of Article 368 over Article 13. All right. And then next came the very landmark judgment in Keshwananda Bharti case versus the state of Kerala. So Keshwananda Bharti, he was a Mathadish, he was a religious person, and when his mutt's property was acquired by the state in the name of land reforms, he contested against this. In the Keshwananda Bharti case, the Supreme Court made a landmark judgment. He said that the Parliament's power to amend any part of the Constitution Parliament's power to amend any part of the constitution was unbridled, and this amending power, Article 368, it overturned the judgment in Golaknath case where it said that Article 368 merely provides the procedure of amendment and does not provide the power of amendment to the Constitution. It said that Article 368 both provides the procedure for the amendment on the Constitution as well as confers the power of amendment on the Parliament. So it recognized powers Parliament to amend any part of the Constitution and take away even fundamental rights Constitution, the Constitution Amendment Act is an ordinary law, right? And uh, it said that it must, however, the amending power of the Parliament would be subject to the doctrine of basic structure, which means that there are certain parts of the Constitution which form the core of the Constitution, which form the core values of the Constitution, and any amendment at taking away those core values can be declared null and void. It said it recognized the absolute right of the Parliament to amend the Constitution as long as it passed the basic feature filter. All right. So this is the outcome of the Keshwananda Bharti case. Now the problem with the Keshwananda Bharti case is that it re-established the supremacy of the judiciary over the Parliament. Do you see that it said that the Parliament can amend the Constitution, but that amendment will always be under judicial review, and the judiciary can very well decide whether this amendment it alters the basic structure or not. So therefore, judiciary would finally have a say in the Constitutional Amendment Act's validity. And if it felt that any act of the Parliament, including a Constitutional Amendment Act, if it takes away the basic feature, if it is against the basic feature of the Constitution, then it would be null and void. Meanwhile, while this was happening, there was another case that happened, the Raj Narayan case versus the Indira Gandhi case. That is also an important case in the evolution of basic structure doctrine. So while the basic structure doctrine was created and established in the Keshwananda Bharti case, in the subsequent cases it was further strengthened. In the Raj Narayan was the political opponent of Indira Gandhi and he was contesting elections against her. He accused Mrs. Gandhi of using electoral malpractices and therefore her election as a member of parliament was contested by him, and therefore it was contested by him in the Allahabad High Court. The Allahabad High Court found Mrs. Gandhi guilty of electoral malpractices, primarily using of misuse of official position as a prime minister to influence elections. That was use of official vehicles and all that, and therefore it said it cancelled the candidature of Indira Gandhi. Now the problem that arose out of the cancelling the candidature of Indira Gandhi was that she was already the prime minister. If she was no more the MP, she could not be the prime minister either. A big problem arose. This case, went into the Supreme Court of India, and while this electoral dispute case, what the government did was it brought the 39th Constitutional Amendment Act. So what happened is around 7th August, this case was brought up before the Supreme Court and was supposed to take a decision on Monday. All right, and the next hearing was on Monday. On Saturday, the state legislature sought 39th Amendment Act was passed by the Lok Sabha around 7th or 8th of August. The next day it was passed in the Rajya Sabha, and the next day it was ratified by half the state legislatures also. In 2 or 3 days this happened. What was the 39th Constitutional Amendment Act? Among other things, it said that the courts have no power to decide on electoral disputes. It said that electoral disputes of the Prime Minister or the President, they are not within the scope of judicial review. The courts cannot call into action that cannot have a say on the electoral disputes of the Prime Minister. All right. So by the time on Monday, when this case came before hearing of the Supreme Court, the judgment said that it accepted the power of the Parliament to amend the Constitution. All right, but however, and it also accepted that the Parliament was capable of passing the laws with a retrospective effect, which means that parliamentary laws would not only be available from the date on which it is passed, but it could also make the effect of the law from a prospective date. This is also established. However, by this time, the government felt these are times of chaos in the country. By this time, the government felt that there was too much liberty, and the government came up with Swaran Singh Committee and 42nd Constitutional Amendment Act. So the Swaran Singh Committee did one strange thing, that it recommended certain fundamental duties to be added to the Constitution. certain fundamental duties to be added to the constitution, something that is not very popular in a democracy. In a democracy, usually, on a liberal democracy, usually we have fundamental rights, but there is no concept of fundamental duties. Fundamental duties are more there in more authoritarian regimes. All right, and the 42nd Constitutional Amendment Act. All right, the first 42nd Constitutional Amendment Act is also often known as the mini constitution. It brought several changes, and among one of these things was Article 31C that was added. 42nd Amendment Act added Article 31C. 31C. What did the 31C say? It says that to implement, all right, so it made a change to Article 31C. It said earlier, what was the position that the law, any law that was brought to implement Article 39B and C of the Directive Principles of State Policy, which means that any law of the Parliament or any action of the Parliament that seeks to implement DPSP Article 39B and C. What is Article 39B and C? Prevention of concentration of wealth in the hands of few and having policies for equitable distribution of wealth, primarily socialist policies. They cannot be void. Any law that seeks to give effect to these DPSPs cannot be declared void if they violate any fundamental right. Now, Article 31 and C said, Article 31C in 42nd Amendment said that not just 39B and C, but if a law is brought by the Parliament, if a law is brought by the Parliament to give effect to any directive principles of state policy, not just socialistic policies, but any articles of the any principles of the directive principles of state policy, it could not be held null and void. All right, and it said that any such amendments, whether past amendments or future amendments, would not be within the scope of judicial review. All right. Now, this came up in the next case, that is the Minerva Mills versus the Union of India. So Minerva Mills was again it was a textile mill. All right. So what happened is it was nationalized. So during this time, the effort, these socialistic principles, the objective was to redistribute wealth in the society, and there was also a movement towards socialistic practices such as nationalization of private property. So in Minerva Mills case, what happened is this private property was nationalized, private property was made a public property, and this case moved from a basic question, infringement of fundamental right, to the wider question of Parliament's power to again amend the constitution. All right. So in this case, Minerva Mills case, what was upheld was that Article 31C, which was amended by the 42nd Amendment Act, Article 31C, which was amended by the 42nd Amendment Act, and said that the Parliament can bring any law to give effect to any directive principles of state policy, was not valid. However, it said that the Parliament could very well bring law that could give effect to Article 39B and C of state policy, and it would not be declared null and void or grounds of violation of a fundamental right. And therefore, it brought harmony between the fundamental right and directive principles of state policy. All right, and therefore it was also harmonious working of the fundamental right and fundamental duty was held as a basic structure. And it reaffirmed in the Minerva Mills case. It reaffirmed in the Minerva Mills case that power to amendment of the Parliament, the power to amend the Constitution, this power of the Parliament is a limited power. Again, this was, in the Vaman Rao versus Union of Case, the last case in this series of cases. What happened was Vaman Rao's case was a private property in Maharashtra, and this land acquisition took away the case, and this, so that it not be contested, the Land Acquisition Act of Maharashtra, this was again put in the 9th schedule. In this case also the judgment came that acts placed from Vaman Rao case onwards, till now it was not there, but from Vaman Rao's case it happened that 9th schedule, any acts of the state government or the union government that are placed in the 9th schedule, which were so far immune from judicial review, would be open to judicial review as well. Any law or regulation of the state government or the union government that are put in 9th schedule to avoid judicial scrutiny from now onwards shall be open to judicial scrutiny and judicial review. Therefore, the Supreme Court's power to review any act of the Parliament was absolute. It could review any act of the Parliament under the doctrine of judicial review. All right. So no, now it also set a deadline. It said that whatever has happened, all the articles, all the acts or regulations of the state government to uh, undertake land reforms before the Keshwananda Bharti case, it will not be under judicial review, but all the acts that have been put in the ninth schedule after the Keshwananda Bharti case, they'll be open to the judicial review. So that brings us to the final position, that what is the final position that we have right now? The final position that we have right now is that the power to amend the constitution, the parliament's power to amend the constitution, is a limited power subject to the basic structure doctrine. The ninth schedule, the ninth schedule, under which is beyond the, which was supposed to, when it was created, it was said that anything that is placed in ninth schedule will not be within the scope of judicial review. Now the position is that anything that is in ninth schedule is subject to judicial review. The power to for an amendment of the constitution to take away fundamental rights, that also exists with the parliament, which means that the parliament can take away fundamental rights as well. So this is the final position that we have right now. All right, thank you, class.